Welcome everyone. Thanks very much for being here today on this Wednesday, March 1st, 2 p.m. We're here in conference room 325 for a hearing of the House Committee on Judiciary and Hawaiian Affairs. My name is David Tarnas. I'm the chair of the committee. My vice chair, Representative Greg Takayama, is here. Sam Kong is returning in a moment, and our other members will be here presently. Today, if you're giving testimony, I would request that you keep your testimony to about 2 minutes, and then I'd ask you to wrap up at that point. And come on up to the podium so everybody can hear you, because not everyone is in the room. They're listening around the Capitol and also online on YouTube. So if you could be at the podium, that way everyone can hear you and see you. If you are testifying via Zoom, please keep yourself muted and your video off until it's time for you to testify. I'll call your name, and then go ahead and testify, and then when your testimony is completed, turn off your video and your microphone again. If you have a technical problem, you could use the Zoom chat function to contact our technical staff, who do a great job here. Thank you, gentlemen. But don't send me a message on chat, because I won't get it. But for technical issues, please use the Zoom chat function. If you're disconnected unexpectedly, don't worry, don't panic. Just join us back up again when you get your internet back up, and I'll do my best to include you at that point to give your testimony. If for some reason we lose power in the Capitol or anything, if we have to reschedule, we will post the appropriate notice to let you know when and where we'll do that. If you are testifying on Zoom, please don't use any trademark or copyrighted images behind you, because that means that our feed will be kicked off YouTube, and that's no fun. So help us out by just not using any trademarked or copyrighted image. And when you're testifying, please refrain from profanity or uncivil behavior. Just, it's okay to disagree, but let's not be disagreeable. We're all here to do the people's business, and so appreciate your kokua. Okay, with that, let's go ahead and start our hearing. First up is House Bill 70, relating to controlled substances. It prohibits the sale and distribution of hemp products that contain cannabinoids created through isomerization, including delta-6 cis or trans tetrahydrocannabinol and their optical isomers. It exempts certain cannabis and manufactured cannabis products sales from the prohibition. And for first up, we have testimony and support from the Department of Health. Welcome. The floor is yours. Please proceed.
Thank you for the opportunity to testify, Chair Tanas and Vice Chair Takayama and members of the committee. My name is Lori Nagatoshi from the Health Department. We stand on our written testimony and support, and I'll be here for any questions. Thank you.
Sure. And if you could just briefly, for those who haven't read your testimony, briefly summarize it.
Oh, we support this measure because it mirrors what we already stated in our interim rules.
In your interim rules?
Yes.
Okay, great. Thank you very much for that explanation. Next, we have testimony in opposition from Minister Hector Hoyos. Is there anyone else here wishing to testify on House Bill 70? If not, questions, members? Seeing none, we'll move on. Thanks very much. Appreciate it. Next bill is House Bill 950, relating to assisted community treatment orders. It extends the time period that a family court may order continued assisted community treatment. Reduces the time period that a family court needs to determine whether assisted community treatment should continue. First up, we have testimony with comments from the State Department of Health. Welcome. The floor is yours. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. I'm Michael Champion from the Department of Health. I'm the Medical Director of the Adult Mental Health Division. The department stands on its written testimony with comments, and also stand in support of the use of ACT as an important tool to use with folks who...
ACT is Assisted Community Treatment, for those who don't know.
Thank you, Chair. Assisted community treatment as an important clinical tool to use with people who are challenged with having a lack of insight into the need for treatment.
And if you would, your testimony you're asking for clarification regarding the data that support these statute changes, because you're unaware of data explaining how the proposed change timeframes will impact outcomes when providing assisted community treatment. Is that accurate?
That's correct. That's the department's testimony. I think the foundation of that is that increasing it from 1 to 2 years certainly will minimize procedural hurdles and burdens to having additional hearings. But from a clinical perspective, seeking information about the data that drives the decision for submitting this particular bill concept.
Great. Thanks for that explanation.
Okay.
Next, we have testimony and support from the Hawaii State Council on Mental Health. Next, we have testimony and comments from the Hawaii Disability Rights Center. Mr. Hurtacek.
Yes, no objection. We'll send
Good.
our testimony.
Remember? Gets you some exercise. Come on up.
I was going to keep it brief and just say that we stand on our testimony. We have no objection to the bill.
Thank you very much. Appreciate it. And next, we have testimony and support from Ellen Godby Carson. Is there anyone else wishing to testify on House Bill 950? If not, questions, members? Nope. No questions? Thanks very much. We'll move on. House Bill 1154, relating to guardianship. Part 1 amends the Uniform Probate Code to allow courts to appoint emergency guardians for respondents who reside in psychiatric facilities, hospitals, and homeless shelters. It clarifies that guardians may consent to care, treatment, or service over the objection of wards. Part 2 requires certain patients subject to emergency hospitalization to be assessed to determine whether a surrogate or guardian is needed to make appropriate health care decisions for the patient. First up, we have testimony with comments from James Koshiba, the governor's office. He works on homelessness in the governor's office. Next, we have testimony with comments from the Attorney General's office. Oh, welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas and members of the committee. I'm Deputy Attorney General Erin Torres. My department submitted testimony recommending amendments to this bill. First, applying the U.S. Supreme Court's established requirements for due process to the amendment on page 1, lines 6 through 8, reveals a constitutional problem. So this amendment should either be deleted or amended as suggested in our written testimony. Second, the amendment on page 3, lines 5 through 7, circumvents HRS sections 334-60.2, 334-121, and 334-161, which contain clear standards that comply with the due process requirements set forth by the Ninth Circuit Court of Appeals and the Hawaii Supreme Court for involuntary hospitalization, assisted community treatment, and the administration of treatment over the patient's objection. In addition, the guardianship statute expressly states that a guardian shall not initiate the commitment of a ward to a mental health care institution except in accordance with the involuntary hospitalization statute. And by analogy, a guardian should not be able to initiate assisted community treatment and the administration of involuntary medications for a ward, except in accordance with those corresponding statutes. Thus, the amendment on page 3, lines 5 through 7, should also either be deleted or amended as suggested in our written testimony. The department respectfully asks the committee to make the amendments we recommend to address these serious constitutional concerns. Thank you for your consideration, and I'm available to answer any questions you may have.
Thank you very much. Next, we have testimony with comments from Matthew Viola in the judiciary. Testimony in opposition from Roland Lee from the judiciary. Welcome. Please proceed.
Good afternoon, Committee Chair. Roland Lee, Office of the Public Guardian Director. We are in opposition of House Bill 1154, and we stand on our written testimony.
And I'll do the same with you. If you could, just briefly explain why you oppose the measure.
Okay. So, current laws authorize courts to bypass the procedural protections and appoint emergency guardians, but only when necessary to avert substantial harm to a person's health and safety or welfare, by allowing the emergency guardians to be appointed solely on the basis of a person's residence at a psychiatric facility, hospital, or homeless shelter, and absent a risk of substantial harm justifying the bypassing of procedural safeguards in the normal guardianship process. This measure drastically deviates from the current practice of reserving emergency guardianships for medical emergencies that are imminent in nature for persons who lack the capacity to make informed decisions regarding their own treatment.
Okay.
Second, because of the impacts on a person's ability to make decisions on self-care, the duration of emergency guardianships should be limited to a time period that are absolutely necessary, and proposals to expand the allowable period should be carefully considered. We note that currently, if a ward does not regain decisional capacity within 90 days of an emergency guardianship, a petition may be filed under the normal appointment process for a guardianship that continues until terminated. Commonly, unlimited guardianship petitions may be filed following an emergency guardianship appointment where the court may calendar the unlimited guardianship hearing to have an unlimited guardianship heard within a 90-day period. Therefore, the amendment in the measure increasing the 90-day duration for emergency guardianships to 120 days appears to be unnecessary.
Okay, that's
Yeah.
good. I appreciate the additional explanation. People who are listening also appreciate it.
And if you have any further questions, I'm available.
Thank you.
Thank you.
Thank you very much. Next, we have testimony with comments from the Hawaii State Department of Health.
Aloha, Michael Champion from the Department of Health. We submitted testimony commenting. One is regarding Section 1, Page 1, Lines 4 through 8, which is potentially confusing as it's written, and offered a proposed amendment to clarify that it's including cases where the respondent resides in a psych facility, hospital, or homeless shelter. And we deferred to the Attorney General on legal matters with this bill.
Thank you.
Thank you.
Next, we have testimony from the Commission to Promote Uniform Laws. Elizabeth Kent.
Aloha. I'm one of Hawaii's uniform law commissioners, and the probate code is a uniform law, and that's why I'm here to testify in strong opposition to this amendment to the uniform law. Although I'm very sympathetic to the problem this seems to address, allowing the appointment of an emergency guardian based solely on where someone resides, an undefined term, is definitely not the way to do it. When I was in law school, I was fortunate to have Professor John Van Dyke for constitutional law. He spoke eloquently about due process rights and our fundamental rights to liberty and self-determination. Surely, making our own health decisions is one of the most important things we can do for ourselves. What really struck me at the last hearing on this bill and in reading the testimony for today was what Ms. Lindsay Ann Pacheco, who I've never met, but what she raised when she talked about her journey out of homelessness. Her personal experiences helped me to realize even more so why the proposed amendments in Part 1 should not be enacted. Thank you.
Thank you very much. Next, we have testimony with comments from the Hawaii Disability Rights Center.
Thank you, Chair Torres. It's good to see you. And,
Thank you.
Representative Kong, Representative Takayama. I'm glad to see Elizabeth Kent because I was going to start my testimony by talking about a conversation we had after the last hearing on this bill. And I don't want to sound facetious, but this is either a very badly drafted bill or there is an intent that is very totalitarian. But if you look at the first page, I think what you're seeing in the testimony, the question had come up about, well, when you want to appoint a guardian, well, would that cover somebody in a psych facility? Would that cover somebody in a homeless shelter? And so the answer is, well, of course, the law covers everybody potentially. But the way this is written, or I think you understand, I don't want to belabor the point, but just merely being there. And I think Elizabeth and I discussed that, and I remember saying, oh no, that can't possibly be their intent. They'll clean that up, but it didn't. So we're hoping that you'll clean that up. The issue of the guardian consenting, there was a time when a lot of us thought maybe the guardian did have the authority to consent to involuntary medication, but I know the Attorney General said they don't, and I've talked with them, and I certainly defer to that. I think that's correct, and so to say they can just consent would not be appropriate. The final issue is the assessment for a surrogate or a guardian. We don't have any objection. I guess I'm just not sure where they're going to go with that. And how long it's going to take. A lot of these folks are brought in on like a 48-hour hold. Guardianship is a whole lengthy proceeding. The surrogacy is usually used for physical health, like end-of-life care decisions. It's not usually used in the mental health context. And what I think what they want to do is they want to appoint a surrogate, they want to appoint a guardian, so they can consent to the medication, which if in the end they can't do anyway, I'm not sure where that whole thing goes. So those are my observations, Representative.
Appreciate that, Mr. Urtacheck. Thanks very much. Next, we have testimony with comments from Hawaii Pacific Health, Mr. Robinson. Testimony with comments from the Queens Health System. Testimony in opposition from Gerard Silva. Testimony in opposition from Lindsay Ann Pacheco. And testimony in opposition from Esther Kim. Is there anyone else here wishing to testify on House Bill 1154? If not, questions, members? Mr. Urtacheck?
Yes, sir.
So I appreciate your concern about the language and what was intended. The judiciary's suggestion to amend it on page 1, where it says, if the court finds that compliance with the procedure of this part will likely result in substantial harm to the respondent's health, safety, or welfare, we change it, take out or where,
Right.
including when the respondent resides.
I think
that way it's clear that it's not just by being in those facilities
Exactly.
that you trigger.
Right. I think that's what they suggested at the first hearing,
So
or something close
just
to
making
that.
sure that comports with
And
your
I think,
rationale.
and the AG, I mean, you would agree with that, and Michael?
Well, it's coming from the AG, so I know they agree with it. I was just checking with you.
Okay, no, I think that's right. I mean, we support the concept, we just want to make sure
Understood.
that they get it right.
Okay.
Yeah, all right.
Great, thank you very much. Any other questions, members? If not, we'll move on. Thank you very much to all the testifiers on this measure. Let's move on to House Bill 1156, relating to health. It's got a very lengthy summary. I'll briefly summarize it. Part 1 authorizes the provision of long-acting psychotropic medication to patients who are subject to emergency examination or hospitalization. Authorizes a psychiatric facility or hospital where a patient is held to request the Department of Health to file a petition for an order for treatment over the patient's objection. Then it expands administration of treatment over a patient's objection to include persons in the custody of the Director of Health at any hospital or subject to a court order regarding fitness to proceed. Part 2 authorizes psychiatrists or advanced practice registered nurses, after examination of a person for assisted community treatment indication, to request the Department of Health or Director of Health to file a petition. Requires family court to file final orders on such petitions within 30 days. On this measure, we have first up testimony with comments from the judiciary, Matthew Viola. Next, we have testimony with comments from the Department of Health.
Aloha, Michael
Aloha.
Champion from the Department of Health. And we submitted testimony commenting on this measure and offering an HD2, proposed HD2, and let me explain that.
Yes.
The department supports the use of these two methods to engage individuals in involuntary treatment. One is assisted community treatment, and the other is an administrative authorization of treatment over objection rather than going through a judicial process. This measure proposes to have the Department of Health really be central for all petitioning or initial procedures with both ACT and AOT. It also proposes that the department formulate a panel to deliberate on whether to authorize treatment over objection. And the department opposes the department's role. It's cumbersome, inefficient, and it doesn't rely on the treating providers who would have the most proximate access to information that they would need in order to have these procedures.
Thank you very much.
Okay.
Next, we have testimony from the Department of Prosecuting Attorneys, City and County of Honolulu. and support. Next, we have testimony in opposition from Hawaii Disability Rights Center. Mr. Urduchek.
Thank you, Chair. This bill is really problematic. The former House Bill 1555 that directs the Health Department to do these petitions, I mean, I think that's a fine idea. A lot of times, let me back up for a second. I've been working on this issue a long time, and I've been trying to work with my colleagues in the advocacy community. A lot of them, I think, really believe that we need to treat or involuntarily medicate people. And they may be right that these people would be better off doing that, but you're still going to follow some legal parameters. A lot of families don't know how to navigate the assisted community treatment law. So having the health director or the attorney general file these petitions, I think, would probably be a big help. But the real essence of the problem that we have is with these administrative panels. I mean, currently, you have to go to court to get a court order to involuntarily medicate somebody. Everybody knows that, or at least, you know, I mean, the case law is really clear. There's a very narrow exception currently in the law. If somebody's at the state hospital and they've already been committed there, the law does permit the hospital to use an administrative panel of doctors to make that decision. That's the only place in the law that it's allowed. At the time that came in, the Department of Public Safety opted not to even use that in the prisons because they had concerns about it. What this bill does is says that you can use that when somebody's brought in on these 48-hour holds. So these are people that haven't been committed to the hospital. They haven't been adjudicated of anything. All they are is some guy laying in the street and a cop thinks he looks weird, so they call a police psychologist on the telephone and they say, okay, yeah, bring him in. They take him to the ER, and under this bill, the next thing you know, this guy's getting injected with long-lasting medication because 3 doctors convened a panel and thought it was a good idea. It's just the Attorney General on House Bill 597, which is a similar measure, testified against it. The public defender said the same thing on Senate Bill 916, the companion that was held on the Senate side. We're sympathetic. I understand there's this revolving door at the hospitals. We see it in our office, so I understand that. But you can't, this proposal is so over the top that to me, it just has no place in the discussion of how we're going to get to actually solving the problem.
Thank you very much. Next, we have testimony in opposition from Scott Greenwood, ACLU. Please proceed.
Thank you. We're actually not here to testify on this measure at all, but on 1154. So I apologize for the.
Oh, no, that must have been my mistake. So, but please proceed.
Thank you, Chair Tarnas and Vice Chair Takayama. So the ACLU strongly opposes House Bill 1154 in its current form, primarily due to the amendments, because they violate due process on their face. What the measure does is to classify as incompetent to make any decisions regarding their own health care or other personal autonomy decisions, people solely on the basis of their residence. So this was either inartful drafting or accidental drafting, or it reflects a more malevolent purpose. I don't want to impute that to the drafters. We associate ourselves with the position of the Attorney General's office, the Public Defender, and the Office of the Public Defender, as well as the Attorney General's office on this issue. We believe that the measure can be corrected so that it will comply with constitutional due process requirements. Thank you.
Thank you very much. Next, we have testimony with comments from the Queens Health System, testimony in opposition from Gerard Silva, and testimony in support from Ellen Godby Carson. Is there anyone else here wishing to testify on House Bill 1156? If not, questions, members? Nope. I recognize that this is a challenging bill, but I don't have any additional questions. I had lengthy conversations with the chair of the Health Committee on this. So thank you very much for the testimonies. Testifiers. We'll move on. Next, House Bill 914 relating to health. It requires the Department of Health to prioritize complaint allegations based on severity for inspections of state licensed or state certified care facilities. First up, we have testimony and support from the Department of Health.
Good afternoon, Chair, Vice Chair, members of the committee. Keith Ridley, Chief of the Office of Healthcare Assurance, on behalf of the Director of Health. The Department strongly supports this measure. The purpose of this bill would expand the Department's ability to more thoroughly investigate complaints on unlicensed care home activities and take appropriate action. The Department's strategy is twofold. One, to investigate complaints, and if substantiated, to close those homes that are operating without a license. The second is to prevent sources of new business by reducing or eliminating referrals to those unlicensed care homes by taking action against those who are doing the referring. In short, what this bill does is it provides for enhanced enforcement activities by the Department of Health, and these are a critical component of the state's regulatory efforts to ensure the health, safety, and welfare of consumers and our kupuna, and such actions deserve our support. Thank you for the opportunity to testify in strong support, and I'm available for any questions.
Thank you very much. Next, we have testimony with comments from the Department of Human Services.
Aloha Chair, Co-Chair, and members of the Vice Chair, members of the committee. My name is Daisy Hartsfield. I'm the Administrator for the Social Services Division in the Department of Human Services, and I'm testifying on behalf of Director Betts. The department did submit written testimony, and basically we are providing information just to clarify that the investigations done by our Adult Protective Services branch are independent of the investigations done by the Department of Health, Office of Healthcare Assurance. But when we do receive a report that involves a care home, a foster home, or a facility that is uncertified or unlicensed, we do cross-report to Department of Health, OCA. And we have had cases in the past where we've worked together. And so whatever can be done to support to DOH, we are in favor of that. Thank you.
Thank you very much. Next, we have testimony in opposition from Alan Johnson with the Hawaii Substance Abuse Coalition. Testimony in support from Martha Randolph with the Kupuna Caucus of Democratic Party Hawaii. Testimony in support from Maribel Tan. Testimony in support from Elma Tierra, Karina Ocampo, Alan Garcia, Christine Ola, Dale Head, and Inam Rahman. Is there anyone else here wishing to testify on House Bill 914? If not, questions, members? Yes, Representative Mizuno.
Thank you, Chair Tarnas. Can I get Keith Ridley back up, please? Mr. Ridley, thank you for being here. I think I saw you the last time. It was on the penalties of illegal care homes. Is that correct?
Correct.
Yeah, now this one is a little different. It's not exactly penalties, but it's to stop. It's to investigate. It's to close these unlicensed, uncertified, illegal care homes. And so would you say this is a consumer protection bill for our kupuna and people with disabilities?
Absolutely, as well as a health bill, yes.
Right. And I remember years past, we talked about this. The legitimate, licensed, certified industry, it's pretty robust. We probably have, I apologize, if you could refresh my memory, over 1,500, maybe 2,000 community care homes, and they care for what, 13, 14,000 kupuna and disabled?
Yes, yes, Representative. The general area of residential care homes includes community care, foster family homes, which are primarily for Medicaid, nursing level residents who would live in a residential home in any neighborhood rather than in an institutional facility. As well, and that generic category also includes adult residential care homes for those who are not on Medicaid, but can include those who are on Medicaid. In total, there are almost 2,000 of those homes throughout the state, mostly on Oahu, of course. There are homes that, of course, are not licensed, and we get complaints about those homes. oftentimes from neighbors who are wondering if the home down the street, who they see a lot of activity on, is in fact licensed. When we conduct an investigation, they are not licensed. We have had situations where we've attempted to conduct an investigation and have been refused entry into the home. In one case, we gathered sufficient information in order to go to the court to get a search warrant. We had to show probable cause for the search warrant, and we served that search warrant and gathered additional evidence of that home operating without a license. We served a notice of violation and order on that home, and that home is still operating, because the case is on appeal. They do have appeal rights. So it's important for us to be able to have timely access to conduct these investigations on homes and be able to access homes when we receive these complaints. Not having that timely access just drags out the process, and residents continue to remain in that unlicensed home and continue to receive the kind of care that may or may not be conforming with regulations.
Thank you. And Chair, could I have one more question,
Certainly.
please? Okay, thank you, Chair. So Mr. Ridley, hypothetically, I'm an illegal care home. So I'm not subject to background checks. I could hire a criminal, a rapist, a murderer to run that illegal care home. And Department of Health, you do not do any unannounced visits or annual visits. You or the Department of Human Services has not certified me. I don't need to get any liability insurance because, again, I'm under the radar, and God knows if I'm paying taxes or not. So is that another reason why we want to make sure these homes that actually provide services to our elderly and disabled are licensed so that the Department of Health, as well as the Department of Human Services, can check on them and make sure ensure quality services to our elderly and disabled?
Representative, that's an excellent question and comment, and I appreciate that very much. We don't know that homes are operating until we get a complaint of them operating. And when we do get a complaint, we check our own records to see if they are in fact licensed. We check Department of Commerce and Consumer Affairs to see if they've registered as a business, et cetera. But because they are not licensed, they don't necessarily follow the requirements for licensure, which would include that the caregivers pass a background check, which includes not only a criminal check, but also the check of registries at the Department of Human Services, the Adult Protective Services, as well as child neglect and abuse registries. We also don't know whether the residents who are in that unlicensed home are perhaps occupying a Harry Potter type under the staircase small room, if there are too many cramped into the room. Whether any remodeling to the home has been permitted by the city or by the county for neighbor islands, or whether they have fire safety, things like smoke alarms, fire detectors, or good egress to be able to get out of the home in case of an emergency. Those are all the kinds of things that we would look for in any licensed home, and we look for those things also when we conduct investigations on unlicensed homes.
Thank you. Thank you, Chair. Thank you, Mr. Ridley.
Thank you very much. Other questions, members? Not, we'll go on. Thanks very much to the testifiers. Next, we have House Bill 794 relating to disability awareness. It designates the month of October as Disability Awareness Month, Employment, Enrichment, and Inclusion, in recognition of the employment challenges and successes of persons with disabilities in the state. First up, we have testimony and support from the Office of Hawaiian Affairs, testimony and support from the Disability and Communication Access Board, testimony and support from the Hawaii Disability Rights Center, testimony and support from Darlene Chen Scoville, and a number of individuals: Alan Garcia, Lisa Smith, Christine Ola, Dale Head, Judy Steinman, and Inam Raman. Is there anyone else here wishing to testify on House Bill 794? Seeing none, questions, members? Thank you. If not, we'll go on. House Bill 110 relating to license plates. It authorizes the use of diacritical marks for Hawaiian words on special number plates. First up, we have testimony and support from the City and County of Honolulu Department of Customer Services. Please proceed. Kimberly Hashiro or representative? No. Well, your test, could you try unmuting yourself? We're not hearing you. We'll go on to the next testifier and keep trying. Next, we have testimony in opposition from Stason Tanaka, Honolulu Police. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Captain Stason Tanaka from HPD's Traffic Division. We're opposing House Bill 110, which proposes the use of diacritical markings for Hawaiian words for license plates, because we believe that this will affect the readability of the license plates, especially at a distance. In addition, the license plates can also be used on the mainland and other states where certain markings may not be readily recognizable. Thank you.
Thank you very much. And we have testimony and support from Dana Keave. And I'll loop back again to see if Kimberly Hashiro can testify at this time. Please proceed. Still no luck? Okay, members, I would refer you to the testimony from City and County Honolulu Department of Customer Services strongly supporting the bill. And in fact, this is their bill. They've acknowledged Honolulu Police Department has submitted testimony in opposition to the bill. They continue its discussion with Honolulu Police Department. And they also note that the American Association for Motor Vehicle Administrators is a national organization that sets best practices, guidelines for license plates, and it does not prohibit use of diacritical markings on vanity license plates and does allow for non-standard keyboard characters to be included on license plates as graphics. So the Okina and the Kahako would be considered graphics. So we'll move on. Sorry we couldn't hear you in person, Kimberly Hashiro, but I've relayed your testimony to the members. Is there anyone else here wishing to testify on House Bill 110? If not, questions, members? Seeing none, we'll move on. Thanks very much to the testifiers. House Bill 1319, relating to the traffic code. It allows operators of bicycles, motorcycles, and mopeds to proceed through an intersection on a steady red signal during certain hours if the traffic signal is controlled by a vehicle detection device that is inoperative due to the size or composition of the bicycle, motorcycle, or moped. First up, we have testimony and support from the Department of Transportation. Next, we have testimony in opposition from Captain Tanaka, Honolulu Police. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. We believe if this bill were to pass, it could increase the chance of a collision as a result of motorists not expecting bicyclists, motorcycles, or mopeds to be crossing in an intersection against a red signal. Thank you.
Thank you very much. Next, we have testimony and support from Ray Pagan. Next, testimony and support from Brant Perry. And testimony and support from Alan Rakes, Terrell Watkins, Michael Ferreira, John Sierra, Manfred Pierce, Corey Gaspar, Ricky Nakamoto, Frank Schultz. Testimony in opposition from Gerard Silva. Testimony and support from Raymar Beilart, Jeffrey Ben, Douglas Levin, Larry Aravalo, Thomas DeMello, Victor Beebe, Edison, Stephen Lauratero, Lisa Jones, Curtis Bautista. Testimony with comments from Andrew Porter. Testimony and support from Lori Glasgow, Tish Rothwell, Kenneth Caldera, and Susan Greenia. Is there anyone else here wishing to testify on this measure? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Next, House Bill 819 relating to Limu Kala designates Limu Kala as the official Hawaii state limu. First up, we have testimony and support from the Department of Land and Natural Resources. Welcome. The floor is yours. Please proceed.
Aloha Chair, Vice Chair, Committee members, Laura Ka'akua with the Department of Land and Natural Resources. The department strongly supports this measure. We stand on our testimony. And I just wanted to add that it's the appropriate time right now, looking at the broad spectrum of bills that are coming through to all of you, from all of you, to recognize state native limu species. Our native limu are really indicators of the health of our entire environment. So when we have a decrease in native limu, or like we see on many of the beaches on Oahu, just a complete absence of native limu, that's an indication that there's no fresh water going into our marine environment anymore, and that there has been a change in the natural processes. And so it's the right time to have a native species recognized, and Limu Kala, for all of the reasons listed, would be the appropriate species to recognize. So mahalo for the opportunity to testify.
Mahalo. Next, we have testimony and support from Jenny Yagodich. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. My name is Jenny Yagodich, and I represent Malama Pupukia Waimea. And we're a community nonprofit that cares for, educates about, and protects our nearshore ocean environment. As a limu practitioner, it's my pleasure to offer enthusiastic support for HB 819 to name Limu Kala as our state limu. This designation will help create much needed awareness about the significance and importance of limu to our marine ecosystem, culture, and our health. So mahalo for hearing this bill, and mahalo for your support.
Mahalo. Next, we have testimony and support from Kevin Chang. Testimony and support from Malia Hemuli. Please proceed.
Aloha mai kākou, aloha representatives. Mahalo nui for hearing this bill today. I am the Limuhui coordinator with Kua'aina Uluwawamo, also known as KUA, and we are in full support of this bill to name Limu Kala as the state limu, and we stand by our testimony. Mahalo.
Mahalo. Next, we have testimony and support from the Malama Limu Club, Kamehameha Schools, Kapalama Campus. Testimony and support from the Marine Science Learning Center at Waianae High School. And testimony and support from numerous individuals: Dana Keave, Leimomi Khan, Carolyn Azelski, Heather McMillan, Pamela Fujii, Jeanette Esquivel, Miwa Tamanaha, Ellie Jones, Kimberly Moa, and Manulani Aluli Meyer. Is there anyone else wishing to testify on House Bill 819? If not, questions, members? Seeing none, we'll move on. Thanks very much for your advocacy for Limu. Next, we have House Bill 1087 relating to the wage and hour law. Amends the definition of employee in Hawaii's wage and hour law by realigning the guaranteed compensation of $2,000 or more to a sum that is at least equal to the monthly earnings of an individual who's compensated at the minimum wage rate pursuant to Section 387-2 HRS, Hawaii Revised Statutes. First up, on 1087, we have testimony and support from the Department of Labor and Industrial Relations. Mr. Butai. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and honorable members of the committee. Jade Butai for the Department of Labor and Industrial Relations. We stand on our testimony in support of the intent of this measure, but we strongly prefer the introduced version to delete the exclusion from coverage for individual guaranteed a monthly compensation of $2,000 or more a month from the definition of employee in Section 387-1. The introduced version will provide more workers with protection afforded by the minimum wage rates, overtime rates, and record-keeping requirements that exist for employers and employees covered under the wage and hour law. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony and support from Hawaii State AFL-CIO, Randy Pereira. Testimony and support from Mitzi Higa, Democratic Party of Hawaii Labor Caucus. Testimony and support from Democratic Party of Hawaii Education Caucus. Testimony and support from Imua Alliance. From Save Medicaid Hawaii, Doris Siegel Matsunaga. Testimony and support from Michael Goyich Sr. And numerous individuals, Will Caron, Justin Salisbury, Talala Tokuda, Tony Radmilovich. Testimony and comments from Greg Crawford. Testimony and support from other individuals, Shay Hodges, Shannon Rudolph, Andrew Isoda, Judith Armstrong, Jun Shin, Diane Ware, Evelyn Howe, and Matthew Grover. Is there anyone else wishing to testify on House Bill 1087? If not, questions, members? Seeing none, we'll move on. Thank you very much. Next, House Bill 692 relating to pesticides. Increases administrative and criminal penalties for violators of the Hawaii pesticides law. First up, we have testimony and support from the Hawaii Department of Agriculture. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. My name is Sharon Hurd. I'm with the Department of Agriculture. We are in support of this bill, stand by our submitted testimony with a few highlights. That the department is asking for an increase in the fines for repeat offenders. The first-time offenders, 1-2 times, those offenders are not affected by this bill, as we do offer warnings. This bill is targeting the repeat offenders, and we ask for the ability to increase the fines that are currently in statute. Pesticide laws have not increased for 22 years for commercial pesticide applicators and nearly 50 years for private pesticide applicators. We ask for your consideration in considering this bill. Thank you.
Thank you very much. Next, we have testimony in opposition from Tim Lyons, Hawaii Pest Control Association.
Thank you, Mr. Chair, Vice Chair, members of the committee. I'm Tim Lyons with the Hawaii Pest Control Association, and we are in opposition to this bill. This bill, we think, is a classic case of one size does not fit all. Fines, of course, are meant to be, as we understand them, to be both punishment and a deterrent. And we just do not see cases, at least in our industry, where the maximum fines have been assessed and that there's a need to increase it because of repetition of those same kinds of fines. So based on that, we oppose. Thank you.
Thank you very much. Next, we have testimony and support from Ann Frederick, Hawaii Alliance for Progressive Action. Please proceed.
Thank you, Chair Tarnas, Vice Chair Takayama, and members of the committee. Thank you for this opportunity to testify, and especially remotely from Kauai. My name is Fern Holland on behalf of HAPA in strong support of HB 692, working and representing our Executive Director, Annie Frederick. Testifying today in support of HB 692 HD1 to increase the fines for pesticide use violations. Chair, Vice Chair, thank you for hearing this important measure. It is clear that there are repeat violators that continuously misuse pesticides and treat it simply as a cost of doing business in Hawaii, and that's unacceptable. The maximum fines have not been increased in a long time, as you just heard, and our Department of Agriculture is underfunded when it's critically needed to expand regenerative agriculture for Hawaii and our food security. So please increase the maximum fine limits for pesticide violations and allow there to be more significant fines to deter repeat violators and encourage them to change their practices. As you have seen in the data that will be submitted by other testifiers, there are a handful of repeat offenders. Also, recently in our ongoing analysis of the restricted use pesticide or RUP data from 2019 statewide, we have seen that 97% of the RUPs that are applied are only 5 users. And the top 10 users account for 99% of the RUP use in all of Hawaii. This measure is not going to impact farmers widely. There are, as you've seen, just these repeat violations that simply need a significant repercussion and deterrent. And we know that many of these pesticides are extremely damaging to human and environmental health, particularly children, developing children, and those who are immune compromised. When you add these considerations to our underfunded DOA situation, this bill is very straightforward. So please support it today. Appreciate again the opportunity to testify, and I'm here should there be any questions.
Thank you very much. Next, we have testimony from Jerry DiPietro. Please proceed.
Good afternoon, Chair Tarnas and Vice Chair Takayama and committee members. Aloha, I am Jerry DiPietro. Hawaii Seed strongly supports House Bill 692, Draft 1. In addition to our written testimony, I'd like to add these comments regarding fines that we must prioritize public safety. We especially must do more to companies who repeatedly violate laws related to highly regulated chemicals. For far too long, the largest users have continually broken the measures that are in place to protect us and the employees in the fields. Being too lax on these repeat offenders is not unlike the repeat offenders we see on the news that drive without a license or have multiple DUIs or long criminal records. It is truly dangerous to not take a strong stand to stop folks from breaking the laws that put innocent people in harm's way. With pesticides, it is the label, it is the law. Repeated environmental crimes and dangerous exposures are well documented. With the lack of integrity demonstrated, I suspect that there are many times these dangerous acts have occurred without consequence. The communities closest to these high chemical use and storage areas have seen and reported many occurrences where noncompliance has gone free of consequence or notice. We know that department staff cannot be on site everywhere all the time, so we are counting on the responsible actions and trusting adherence to the law. Not only is this trust and honor of the laws expected, but it is the right thing to do for the safety of their workers, neighboring crops, waterways, critical habitat, and most importantly, residents. The state's current low fine threshold does not create a sense of urgency to change behavior and stop repeated violators. We ask that you please vote to support House Bill 692, Draft 1. Mahalo and aloha for the opportunity to testify.
Thank you very much. Next, we have testimony and support from Kolur Bandera. Testimony in opposition from Jonathan Montalvo with Aloha Termite and Pest Control. Testimony in opposition from Wekan Childers with Bomite Termite and Pest Management. Testimony in opposition from Tanya Plunkett with Bowman Termite. Testimony in opposition from Michael Ector with Bowman Termite. Testimony in opposition from Lucille Castro. Testimony in support from Chris Caulfield. Testimony with comments from Steve Tevez. Testimony in opposition from Stephen Russo. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon. My name is Steve Russo. I'm the Regional Support Manager for Terminex here in Hawaii, the largest pest control operator in the state. I'm also a certified applicator. I've been a certified applicator for over 14 years. And prior to working for Terminex, I worked for the Hawaii Department of Agriculture at the pesticides program, where I did enforcement work and education work. In my experience, well, first of all, a $5,000 fine is a significant fine. It is a deterrent. As far as, am I willing to allow people to accrue those kinds of fines? No. Right? And we take a lot of actions. We provide a lot of training through our association, through our manufacturers, to try to educate our workers in our industry. In my experience, most people breaking pesticides law were actually doing so out of ignorance. And if our purpose is to reduce misuse, I think increasing our educational output from the state, especially to non-English speaking pesticide users, is really going to be a more effective strategy than increasing a fine. The last thing I would say is that most pesticide users in the state are relatively small businesses, family-owned businesses. A $5,000 fine is significant to a small business. A $10,000 fine would probably just drive them out of business. So I think when we look at what we're trying to accomplish here, reduce misuse, a $5,000 fine is a significant deterrent. So thank you. I am opposed to it.
Appreciate that. Thank you very much. Next, we have testimony in support from the following individuals: Nanea Lowe, Nathan Brolick, Dawn Webster, Mary Lou Kelly, Marilyn Mick, Kate Payne, B.A. McClintock, Dana Kiave, Pamela Burrell, Jun Shin, Ezgi Green, Carolyn Azelski, Cards Pintor. Testimony in opposition from Clarence Ka'ai. Testimony in support from Marlis Lee, Kalakai Hammond. Testimony in opposition from Natalie Yaji. Testimony in support from Jimmy Gomes. Testimony in opposition from Jamie Gutierrez and Jasmine Harmon. Testimony in support from Brandy Corpus, Mary Laquez. Testimony in support from Marion McHenry and Joseph Watt. Is there anyone else here wishing to testify on House Bill 692? Mr. Kubo, welcome.
Clayton Kubo, Waimea, Kauai. If $5,000 was enough, then we wouldn't have the 65 pages that I'd send each and every one of you on this committee. So if you add, just give them one round figure, maybe 12, it's almost 800 repeat offenders. It's like, when you guys gonna do something?
You're testifying in support?
Yes, I am testifying in support. But when you guys gonna do something that these people, or these so-called professional applicators, that I was told over and over, the label is the law. Many, many years, the label is the law. We're not trying to do any harm to you guys. But please look at the documents that I send you guys, and I'd like to add on, correct me if I'm wrong, okay? 4 more. Just recently I received, so pretty sure, right? Or 2 more, but I see 4 on that list.
Hey, Clayton.
Scott.
Okay. You got to look at the camera. Everyone wants to see you.
Okay, so please do something about this, because this is definitely one problem, one major problem. Mahalo for you guys' time. Aloha.
Mahalo. Thanks for being here. Anyone else wishing to testify on House Bill 692? If not, questions, members? Any questions? Okay, thank you for bringing this serious attention to our attention. And I appreciate all the testifiers, pro and con, on this measure. Let's move on. House Bill 1348, relating to labeling of macadamia nuts. Clarifies labeling requirements for macadamia nuts, requires country of origin to be included on the label of a consumer package of raw or processed macadamia nuts, and allows a private right of action for violations. First up, we have testimony and support from the Hawaii Department of Agriculture. Welcome, Chairperson.
Good afternoon again, Chair, Vice Chair, members of the committee. Sharon Hurd, Department of Agriculture. Thank you for the opportunity to testify on this bill. It also affords me an opportunity to correct previous testimony made on this bill where I mistakenly referred to a company as in violation because they didn't purchase local macadamia nuts. And I should have stayed with the concept that this is a labeling bill. And what we're trying to do through this bill is align it with the federal country of origin labeling requirements. And we're asking for the industry and the people that are involved in macadamia nuts to follow the labeling law of the content, what's inside. If you have 50% Hawaiian macadamia nuts, let's stick with that. But I received new information, and I realized that it is not the responsibility of this bill to talk about the companies that might be or might not be purchasing local. So that was my comment. We're here for questions. Thank you.
Thank you very much. Next, we have testimony in opposition from Michelle Leon Guerrero, Chief Administrative Officer, Hawaiian Host. Welcome. The floor is yours. Please proceed.
Thank you. Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. My name is Michelle Leon Guerrero, and I'm the Chief Administrative Officer for Hawaiian Host Group. Our brands are Hawaiian Host, Mauna Loa, and Koho. Although we understand the intent of supporting the macadamia industry, we are strongly opposed to HB 1348 HD1 as it is currently written, and I stand on my written testimony because of the potential negative impact that it may have on many local businesses and local jobs. Hawaiian Host has been in Hawaii for almost 100 years. And our founders, Mamoru and Aiko Takitani, were the inventors of the very first chocolate-covered macadamia confections, which has paved the way for Hawaii macadamias and is known all over the world. We currently employ over 300 employees across our islands and have 2 manufacturing facilities, one in Honolulu and the other in Kea'au on the Big Island. Many of our employees have been with us for decades, and we even have multi-generational families working side by side in our factories as well. Our employees are really proud to be part of a company with a long-standing commitment to growing in Hawaii. In its current form, HB 1348 HD1 creates significant financial burden for local businesses like Hawaiian Host, which could lead to the loss of local jobs. We're concerned if the precedent is set like this for macadamias and coffee, it could have a ripple effect for other local agriculture and local businesses. Many local companies like ours continue to invest in creating new value-added products to remain competitive and serve the changing needs of consumers while striving to survive with significant increased costs every year for doing business. Although the labeling requirements may seem small to some, this would cause a huge financial burden in wasted packaging and replacement packaging. There's also a concern that due to logistical delays that still exist even after the pandemic, that the lead times companies would have in order to comply would be challenging because of the length of time it takes to get things to our islands. Most importantly, we believe this is an example of burdens placed on local businesses, and it makes it more challenging, to continue for local legacy Hawaii companies to survive.
Thank you. If you could summarize the rest of your testimony,
Sure.
that'd be great.
We would like to request the opportunity to form a working group that's made up of growers, producers, and other companies to be able to work together to find a really good solution to support the long-term success of the macadamia industry. So for these reasons, we would like to ask the committee to please defer HB 1348 to be able to work on this at that time.
Thank you very much.
Thank you.
Appreciate your testimony. Next, we have testimony support from Jeffrey Clark, Edmund C. Olson Trust. Welcome. The floor is yours. Please proceed.
Aloha. Chair Tarnas, Vice Chair Takayama, remaining members of the committee. My name is Jeff Clark. I'm the Chief Operating Officer for the Edmund C. Olson Trust. We own Hamakua Macadamia Nut Company and Ka'u Farms Management. So we have a farm and we have a processing facility for macadamia nuts. I'm also on the board of the Hawaii Macadamia Nut Association and the Hawaii Macadamia Nut Growers Association, which focuses on the farmers. I stand in support of this bill, strong support of this bill. This is a bill that is necessary because we have a major problem at the farm level in farming macadamia nuts. It's at the point where we're starting to lose farms. And so we're standing together to bring this bill forward because we feel like we need to protect macadamia nuts as a crop, similar to coffee, right? Similar to other regions that other states have done across the United States, right? Whether it's Idaho potatoes, whether it's Napa Valley wines, Vermont maple syrup, there's a whole host of regions and states that protect their key commodities, right? The macadamia nut industry was started in Hawaii, essentially, on a commercial basis, and the macadamia nut is highly identified with Hawaii. And so what we want to do is we want to protect the farmers. I mean, at this point, we're looking at farms that are failing, and part of that is because foreign nuts have come into the state, and they're going into retail packaging that portrays itself, we feel, as Hawaiian. there's been opposition to the bill, of course, as you've heard. And a lot of the opposition has to do with the financial impact. I think what we really need to do is we need to look at this and understand that there's a major financial impact on the farmers. There's 620 farms across the state, most of which are on the Big Island. A lot of them are small little farmers, right? And so, we need to protect the industry, protect those farmers. It's really thousands of jobs. It's 620 farms, but there's a lot of, pickers and workers that work on those farms. So we have to not only consider the economic impact at the retail level, right, for the brands and the processors, but we got to look at the farms. And, the MacNut industry was built at the farm level, right? The macadamia nut farmers are the ones that build the reputation of high quality, right? They build the reputation of, a premium macadamia nut. So there's a reason why brands would want to, portray themselves as Hawaiian, because it's a premium brand, right? Hawaii stands for premium in a lot of people's minds.
If you could summarize the rest of your testimony, it'd be great.
Thank you, and I urge you to support the bill and think of the farmers.
Thank you very much. Next, we have testimony from Vivian Fung, Luke Octavio. Please proceed. Go ahead, Luke Octavio.
Hi, good afternoon. Aloha. Good afternoon, Chair Connors, Vice Chair Takayama, and members of the committee. I'm sorry, I don't think my video camera is.
It's okay. We hear you, so you can proceed.
Okay, terrific. My name is Luke Octavio. I'm a production manager at Mauna Loa Macadamia Nut here on the Big Island, TL. I've been with the company since 1994. This is going on my 29th year here at the company. And we're really proud of our Mauna Loa brand, and it's iconic. It's iconic to Hawaii, and a lot of people in the plant has got decades of working here, 20, 30, 40 years. At this point, I oppose the HB 1348, HB1, and it's currently written. Its current form is too broad and vague, leaving people to their own different interpretations of what company names or images should be prohibited or permitted under the proposed new labeling requirements. Assuming the bill language was clarified in macadamia brands to understand what is and isn't prohibited, it will be impactful to implement a complete packaging redesign as stated earlier. It will affect, countless jobs on the Big Island, potentially. And the lack of clear guidance under this HB 1348, HB1, will result in a lack of consistent compliance and enforcement, which will not improve protections as this bill aims to do. Again, I want to thank you for the opportunity to submit my testimony, and aloha and mahalo.
Mahalo. Thanks very much. Next, we have testimony from Ed Schultz, Mauna Loa Macadamia. Mr. Schultz, please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. My name is Ed Schultz. I'm the President and CEO of Hawaiian Host Group, which, as you've heard from my colleagues, includes Hawaiian Host and Mauna Loa. Look, we support the intent of House Bill 1348 to strengthen existing protections for macadamia nut farmers and consumers, but we oppose it as it's currently written. As we've heard, the bill is very broad and vague and problematic for these reasons. It leaves a ton of interpretation and conflicting interpretations regarding what company names or images would be prohibited under this labeling requirements. This lack of clear notice regarding what is prohibited will result in a lack of consistent compliance and enforcement. I think one of the biggest things about the bill is also the broad and vague language, coupled with the private right of action, provides a floodgate of lawsuits, which will unnecessarily increase the cost of doing business in Hawaii and the cost of the goods to residents and consumers. The bill could also prevent the use of certain federal registered trademarks, require their alteration, and given a rise to conflict between state and federal law and interstate commerce. While we remain concerned that people will not know how to comply with this, and even if they did, the bill doesn't have any phase-in time. As you heard from my colleague Michelle, the size of the company and the number of jobs we have, it takes us 6 to 12 months to change a label and packaging. And you just can't flip stickers in its place. That's not a viable solution either. So there needs to be, no matter what we come up with, a runway here to potentially change packaging requirements. Look, we're committed to a sustainable and transparent industry, including for protections from macadamia nut farmers and consumers. But as it's written, we believe the bill is defective and will not provide these protections. I think we should work together as an industry to find solutions that make sense, build our industry up together, including new resources and new production facilities that will benefit everybody. But this bill is not it. So for these reasons, as described more in my written testimony, we at Hawaiian Host Group and all of our employees respectfully ask that you hold this measure. Thank you very much for the opportunity to testify today.
Thank you very much. Next, we have testimony in support from Andrew Trump, Island Harvest. Welcome, the floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and the members of the committee. My name is Andrew Trump. I'm a second-generation macadamia farmer testifying on behalf of Island Harvest, an organic macadamia nut farm on the island of Hawaii. I'd like to stand on my written testimony in support of HB 1348, but first I'd like to emphasize a few key points. I'd like to clarify that this bill is asking macadamia brands to put the origin of their macadamias on the label for consumers to see. Just like any other labeling law, brands can continue to use their trademarks and brand names if they comply with this labeling law, and they would not be prohibited to do so. Additionally, I'd like to point out that there's precedent for country of origin labeling at the federal level through Section 304 of the Tariff Act of 1930. And there's also precedent for state-specific laws to protect the integrity of important agricultural products, such as laws that have been passed for things like we've heard already, Vermont maple syrup, Florida oranges, and Idaho potatoes, to name a few. So this isn't new. It might be somewhat new to our state, but it's not new to the U.S. and can comply in those ways. And as a farm, we also support allowing macadamia brands time to comply with HB 1348, and we'd recommend using the setting of an effective date or a safe harbor clause to allow brands time to comply like ourselves. And then finally, we support the further clarification to Section 1B and offer a possible alternative in our written testimony to address some of the vagueness concerns that have been brought up today. Macadamia farmers, like myself, are simply asking for truth in labeling. Mahalo, and I'm happy to answer any questions.
Thank you very much. We received lots of written testimony. In addition to the people that we've heard from already or I've called, there are an additional 40 testifiers in opposition and 116 testifiers in support. Is there anyone else here wishing to testify on House Bill 1348? Yes, please come on up, introduce yourself. The floor is yours. Please proceed.
Hi, aloha, Chair Tarnas and Vice Chair Takayama. I am Kamale Grace. I am the office manager over at Hawaiian Host Group, and I just wanted to stand on my written testimony in opposition of HB 1348, as it is written. Like my colleagues and team members have mentioned, we are just looking for more time to work together with other farmers, growers, and businesses, as well as the legislature, to kind of come to an agreement that we can be beneficial for everyone and protect the community, as we are looking to do as well. Thank you.
Thank you very much. Is there anyone else here wishing to testify on this measure? If not, questions, members? I have a question for the Department of Agriculture.
Chair Tarnas?
Thank you. Appreciate you being here. Is there a requirement for companies selling macadamia nuts here to state their country of origin on their label?
No,
I understand there's a federal law,
yes.
so there is a law.
The federal law, pretty much country of origin labeling pertains to the fresh produce. They have made exceptions for certain commodities. Macadamia nuts is one, fur products is another, but there is a federal law.
So the federal law, does the federal law requiring country of origin apply to macadamia nuts?
Yes.
Okay, so there is a law requiring people who sell macadamia nuts in their product, even if it's an ingredient, they have to state what is the country of origin of the macadamia nuts.
Yes.
Okay.
But may I call on
Who enforces that?
the enforcement group?
Okay, that's your intro. Could you introduce yourself, please, sir?
My name is Richard Cohen. I'm the Measurement Standards Program Manager for the Department of Agriculture. Thank you for your question, Representative Torres. Chair, Vice Chair in the committee, I'm very happy to be here to answer any questions. I'm not quite sure what the answer is about the federal law. That's something that I recently found out about. We have our law, which is 120.5 HRS, which requires the producer to label 100% Hawaiian macadamia nuts or Hawaiian macadamia nuts if they are such in fact, or if they're not Hawaiian macadamia nuts, they cannot. This language in this bill just emphasizes the fact that they would have to state the truth in labeling of where the macadamia nuts were coming from. Most of the companies that have been producing the products using the macadamia nuts have been buying pretty much Hawaiian macadamia nuts for many, many years, 40, 50 years. And the farmers are concerned because a cheaper substandard brand has been introduced into the marketplace and the consumers don't know what they're getting. So that's why I think this bill has come up. A simple answer for the companies that are using the macadamia nuts is if they were buying all Hawaiian macadamia nuts, they wouldn't have to put anything on the label that they were using foreign macadamia nuts.
So if somebody, someone who produces macadamia nut products here, sells them here, and they purchase macadamia nuts from somewhere outside of Hawaii, they're supposed to put that on the label, that they are foreign.
I believe that the federal law requires them to put that on the label, but that's something that
But the state law that you referred to.
There's nothing in the state law.
Okay.
Right now, unless this bill is amended,
Okay.
there's nothing in the state law
Okay,
that
and
says that they have to do that.
One last question. Who enforces the federal law?
I believe USDA.
Okay. Okay, thank you. Other questions, members? Representative Hashimoto.
So I guess since you're up there, Department of Ag, so this is, let me just understand this clearly. So this is only for the things that are manufactured in Hawaii that you have jurisdiction under?
That's correct.
So anyone could be manufacturing elsewhere, right? And they could use whatever macadamia nuts they want, and they could send it to Hawaii, and it could be Hawaii-grown macadamia nuts. Would you enforce that as well, but not manufactured here?
You're referring to 46-119, the Made in Hawaii law?
No, I'm just saying, you want a label, right, to say that it's grown in a different
Okay.
country, but how do you regulate that if it's not even manufactured here?
Thank you for the question. It is 46-119 that says, even if your content is 100% Hawaii, if you take that and manufacture it, assemble, fabricate, publish on outside of Hawaii, you cannot state that your product is made in Hawaii, even if you
I'm not saying it's
100%.
made in Hawaii, I'm just saying it's Hawaiian, right? You look at Frito-Lay, they say Maui-style chips, right? So how do you regulate that?
We do have,
Especially because it's
it's
manufactured elsewhere and sent back here,
and
right?
there's been several cases about that. It's against the law because that particular law I referenced earlier, 46-119, says by any other means.
But I'm saying it's not the Made in Hawaii law. It's It's just saying
Okay, manufactured. In fact,
Hawaiian-style chips, right?
right, there was a case where the specific example you're talking about, chips, was taken, was it P? It started with a P. I'm going to say Paradise Chips or something like that. They were cited and they were fined because they had Maui style, local lava chips,
Right.
and they were taken off the market.
So I just went to Costco and there's still Mao-style chips, right? So if you can guarantee that you're going to regulate every single product, then I might be okay with this bill. But if you can't guarantee that you'll be able to regulate this, I'm not sure I'm in favor of something like this.
I believe the Maui-style chips are made by Frito-Lay. There's a statement of origin on the back of the package that's manufactured in Texas, and they're not presenting it to be a Hawaiian product. It's something that's deceptive because of the way they're using the Maui-style chip name and logo. And they may be trying to take advantage of the Hawaiian culture by doing that. But they do state plainly on the packaging that it's not produced in Hawaii and it's not a product of Hawaii.
So you're saying that but it doesn't answer my question of manufactured elsewhere. So are you going to enforce that labeling though of something coming outside of Hawaii that's and being sold in Hawaii, and and they don't put that labeling? Are you going to go after them even though they don't do business in Hawaii, but they're sending their products here? They're not manufactured in Hawaii.
Representative, we do not. We are asking for more inspector positions, but largely I'm going to say that we're complaint-driven. And when we do receive a complaint, we do investigate, and it has resulted in some significant penalties. I'm going to state the Kona Brewing Company was one. I think their fine was $20 million. So we are complaint-driven, and I don't think we go out there and we actively look at labels. So yes, we don't.
I guess what I'm trying to get at is I think you just need to watch what you're asking for, because I think you're opening Pandora's box of, if you're going to start with this, you just got to make sure that you're going to be able to enforce this. That's my concern.
I see. Okay.
Do you believe you can enforce this?
This was an industry bill. And so when this...
I know it's an industry bill, but I'm asking you as the Department of Ag who has to enforce
With
it,
the
right?
proper staffing, I would say maybe 2 other inspectors. What do you think?
But are you requesting that in this bill?
Yes, we are. But actually, there's so many label bills right now. This is one. We have one for coffee, and now we have one for hemp. So when these... Oh, yeah, I forgot Mamaki tea as well. So when these bills come through the wash, we'll see at the end how many of them we need inspectors to enforce.
So at the current time, you're not sure then?
At the current time, we do not have the inspectors to do all of these labeling projects, hemp, Mamaki.
Okay. Thank you, Chair.
All of them. So we do not. All right? Thank you.
Other questions, members? First over here, Representative Holt.
Thank you. I guess for the Department of Ag, since you guys are just a practical question. How do you guys, if they brought you 2 nuts, would you be able to tell where they're both from?
I'm going to say we couldn't, but there is technology now that the coffee industry introduced where they can actually check for markers and determine whether or not that particular product.
So you guys would be in charge of enforcing, but you cannot enforce it.
We would need that technology.
And are there any other cases where you guys are in charge of policing people's company names?
Actually, they had a bill maybe 2 years ago, and it was given to DBET for a sense of place, misuse of the Hawaii brand. So we participated in that study, and that study determined by checking all the different companies that use Niihau or misplaced use of Hawaii. They determined that there's a $14 million loss to Hawaii companies. That was the conclusion. And so the next question is, so now that we've quantified the loss, what do you do about it? So we don't particularly police, but now we have the number. We know what the loss is. So maybe the industry can say, well, look at all this. We're losing all this money to these mislabeled products. So let's get some funding, and now we will produce. I will add to some of the testimony that one of the unusual place protections is Wisconsin ginseng.
they have a pretty strong presence protecting their Wisconsin, and they come out to Chinatown, every so often to protect their Wisconsin ginseng. But it takes a lot of money. Idaho Potato is funded by millions of dollars, and they enforce terrific. They're wonderful with enforcement. So we need the funding to do the enforcement.
Well, I think, we have a bigger issue. There's so many different, if we keep going down this line with every single different product, I think the Made in Hawaii thing was kind of the reason we came up with this, so that we can go on the offensive instead of trying to maybe knock other people down, so we can just help each other all out instead. So, thank you, Chair.
Thank you.
Thank you very much. Questions over here? Representative Ganadin?
Just in response, in hearing that this is largely complaint-driven, if we were to pass this out, do you think Section G is necessary, which allows person to bring a civil action? I'm guessing for the statute that person could be a corporation, an entity, an LLC, something like that.
I believe that was some of the information that I received this morning, which made me adjust my testimony previously. Did you want to address that?
No, he's asking you.
Oh, okay. So from what I understand, that's the industry is considering that might be a nuisance part of this bill, and they're asking the same thing. They're asking to remove that in the next amendment.
Thank you.
Okay?
Thank you. Other questions, members? Representative Kong.
Thank you, Chair. Jeffrey Clark, please. Yes, sir. Obviously, we want to support the macadamia nut industry. There is no doubt there. So we're looking at this bill. But in any case, I have a quick question. It's mentioned that you're seasonal, the macadamia nut industry
Yes, it
is
is.
seasonal?
Yes.
What is that season?
It'll run from about mid-August, and it depends on what part of the island you're on. But so for the whole season, if you're receiving nuts from the whole island, on the Big Island, it'll run from about mid-August through about May. So it's a pretty long season.
Okay.
Yeah.
Okay, that helps. Because, you mentioned that the largest brands do not purchase most of their mac nuts from Hawaiian growers.
Yes.
Is it because of supply that you know, right?
No.
So,
No.
what is the reason for this? Just
cheaper.
monies?
Cheaper. It's much cheaper. They can actually buy macadamia nuts from, say, South Africa or Kenya for less than we can produce, right? That's the math. It's pretty simple, pretty straightforward.
But at 51 million pounds that you do sell, where does that mac nuts go?
Well, right now, there's 51 million pounds produced in the state.
Yes.
Unfortunately, right now, inventories are building up, and nuts are on the ground. So farmers aren't even picking them up. So we have a few issues, right? So the farmers that aren't picking them up are either considering taking out their orchards, saying, hey, this mac nut thing isn't working anymore for me, so I gotta think of my next crop, or I gotta sell, or whatever. At the processor level, so we have a farm and we have a processor. Inventories are building up as we're unable to sell into the market. So again, it's when you're competing against a foreign grown product, in a Hawaii bag, you're getting the premium price with the low cost. And let's face it, that's why they're doing it. Let's not mince words here. That's exactly what they're doing, right? And so that's why we're here today, right? That's what brought us here today, is that you got a major Hawaiian brand, and there's no doubt they are. They're the leader of the MacNet industry. And this has been going on for years, by the way. So this isn't like a new thing, but it's the volume of what's happened that's really taken us to this point where everybody's like, whoa, wait a minute. Now we have nowhere to go. The industry is stuck. And so, on the farm side of things, it's a real problem.
Okay, understood. Because you heard from the Department of Ag, we're looking at a lot of labeling bills. We've been through the coffee labeling bills for years now.
Yes.
So
I testified yesterday on another one.
So I'm just looking for solutions to help you. Labeling might not necessarily be the holy grail to answer your problems, but that's why I asked these questions. So thank you for your time. Thank you, Chair.
Thank you. Thank you, Representative. Other questions, members? If not, we'll move on to the last bill. Thank you very much to the testifiers on this measure. Very important measure. Let's move on to the last bill on our hearing, HB 201, relating to historic preservation, expands the definition of historic property for purposes of the Historic Preservation Program. First up, we have testimony and support from the Department of Land and Natural Resources. Welcome. The floor is yours. Please proceed.
Laura Kakwa from the DLNR. The department supports this measure, which defines historic property based both on age and historic association. We believe that defining historic property just based on age alone is the problem, and so we recommend an amendment that we hope you'll consider adding, which is to delete the provision of 100 years old. If we just define any building that's over 100 years old as historic, that could lead to unintended consequences where we're preserving buildings that maybe do not have particular historical significance and are merely just old. So we think that the 50 years plus the criteria of historic importance will suffice. Mahalo.
Thank you very much. Next, we have testimony and support from Hawaii Realtors. And testimony and support from Evan Oy. Welcome. The floor is yours. Please proceed.
Aloha Chair, Vice Chair, members of the committee. Evan Oy testifying on behalf of NIAP Hawaii. We support the intent of this measure which is designed essentially to reduce the volume of permit reviews and SHPD reviews for projects throughout the state. However, we do have some concerns with the amendments that were made to in the HD1. We do appreciate the work of the previous chair, but the concern is primarily that adding the vague criteria as provided in the HD1 would result in potentially nullifying the intent of the bill to reduce the review of these the permits of these projects. Essentially, it would create another process for there to need to be the determination need to be made for buildings over 50 years old if they meet these criteria, and then that would further extend the review process. So and it's just a little vague as to who may be making that determination as well. So respectfully, we do prefer the language of the original bill, which does include the 100 years as an alternative, potentially noting a specific date in which buildings constructed before that date would be deemed historic, and if it meets the criteria as well. We're open and want to discuss, potential language in which balances the interests involved here, and we're looking forward to working with any stakeholders. So thank you for the opportunity. Available for any questions.
Thank you very much. Next, we have testimony in opposition from the Historic Hawaii Foundation, testimony in support from Maui Chamber of Commerce, testimony in opposition from Sarah Collins, testimony in support from Ka'au Nesmith, and testimony in support from Dana Kiave, and testimony in opposition from Rona Ikehara Cabral. Is there anyone else here wishing to testify on House Bill 201? If not, questions, members? Seeing none, thank you very much to all the testifiers. We will now, that has been all of the bills that we've had for consideration. I'd like to move on to decision making. Everybody's here who can be here. Get my notes together. And again, thanks to all the testifiers for helping us out with these measures. Okay, first up we have House Bill 70 relating to controlled substances. I recommend that we amend this bill with some technical amendments to correct some misspelling and move it out. So it's HD2 with just some corrections for misspellings only, technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 70 HD1 with further amendments. Chair and Vice Chair vote aye. Representative Ganadin.
Aye.
Representative Holt.
Aye.
Representative Hashimoto.
Aye.
Representative Ichiyama excused. Representative Ilagan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you. Next, on to House Bill 950. That's an important measure. I'd like to move this out as is. Any questions or concerns, members? Not, Vice Chair, for the vote.
Voting on House Bill 950 HD1, passing as is, noting the excused absence of Representative Ichiyama. Any reservations or noes? Seeing none, your recommendations adopt.
Thank you very much. Next measure, House Bill 1154. I have the concurrence from the Health Chair to make some amendments. Not all the amendments I wanted to make, but she gave me some concurrence to make some amendments. On page 1, lines 6 to 8, I want to take the recommended amendment from the Attorney General. Page 1, line 6 to 8. So we're going to, instead of saying, I'm going to read it. If the court finds that compliance with the procedures of this part will likely result in substantial harm to the respondent's health, safety, or welfare, and we're going to take out the words "or where" and put in the words "including when the respondent resides in a psychiatric facility, hospital, or homeless shelter." I think that should make it clearer what the intent was supposed to be in the first place. And then I have permission to incorporate the amendments from Hawaii Pacific Health in their testimony, which is on page 5, adding some language that when their patient is examined by emergency department who is determined to be imminently dangerous to self or others by an emergency room physician or psychologist, and later in that same section adding the words "and emergency room physician and psychologist," in addition to what is already there, which is psychiatrist and advanced practice registered nurse. So those are the two amendments that I have been given permission to make. So that's the HD2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1154 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Any reservations or noes? Seeing none, your recommendations adopted.
Thank you. Next, House Bill 1156. I recognize that there's a lot of concerns with this bill. I did not get permission to make all the amendments I was hoping to make, but let me describe the amendments that I do have permission to make. The way this works, just so people know, is that we're an afternoon committee. That means we get the bills after it's gone through earlier committees. In order for me to make an amendment, I need to get prior concurrence of the chair of the earlier committee. If I don't get that prior concurrence, I should not make the amendments. So I follow that rule. That's what we're doing. So on this one, House Bill 1156, the amendments that I would like to make on page 3, I want to add Behavioral Health Crisis Center to the list there, which is already including psychiatric facility and hospital. So we're adding Behavioral Health Crisis Center. On page 8, adding the same words in 3 locations on line 8, line 16, and line 20. And then on page 22, we're adding a new section that states the Department of Health shall submit a report on the number of requests for petitions for assisted community treatment submitted to the Director of Health since July 1st, 2023 to the legislature no later than 20 days prior to the convening of the regular session of 2025. I recognize that there were a number of other amendments people wanted to make. We'll have to work on them later. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1156 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Any WRs or noes? Your recommendations adopted.
Thank you, and bless you, Representative Candidate. Next, we have House Bill 914. On this measure, I'd like to move it out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 914 HD1 passing as is, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendations adopted.
Thank you. Next, House Bill 794 relating to disability awareness. This designates the month of October as Disability Awareness Month. I'd like to pass this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 794 HD1 passing as is, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you very much. Next, House Bill 110. I recognize the police.
Sorry.
I recognize the police department was concerned about this, but I also heard from the City and County of Honolulu that they're working with the police department. I'd like them to keep doing that, so I want to move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 110, HD1, passing as is, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you very much. Next, moving on to House Bill 1319. I recognize the police have a concern with this. Department of Transportation thinks it's a good idea. Obviously, a bunch of other testifiers think it's a great idea. So I'd like to make some technical amendments and move this out with House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1319, HD1, with further amendments, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next, House Bill 819 relating to Limu Kala. I'd like to make some technical amendments and pass it out as a House Draft 2. Questions or concerns, members? Not, Vice Chair for the vote.
Voting on House Bill 819, HD1, with further amendments, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1087. I have prior concurrence from the Labor Committee Chair to adopt the recommended amendments from the Department of Labor and Industrial Relations and make some technical amendments. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1087, HD1, with further amendments, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you very much. Next, we have House Bill 692. I hear the opposition from the applicators and the folks involved in trying to control pests who use pesticides, but I also recognize that this is an important matter that I think needs more attention. I'd like to move this forward as is and keep the defective date so we can continue discussions on this. So that's my recommendation. Move it out as is with still the House Draft 1. Questions or concerns, members? Representative Hashimoto.
Thank you, Chair. I think in the future I'd like to see this bill, I don't know, possibly bifurcated to figure out how to move out the things that really are under DOA versus other pesticides, that are used for applicators like the termite inspectors and whatnot. So for now, I'm going to vote no on this measure. Thank you.
Understood. Other questions or concerns, members? And that's a good suggestion. Maybe we can talk to the introducer and see if we can work on that. Okay, any other questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 692, HD1, passing as is, noting the excused absence of Representative Ichiyama and the no vote of Representative Hashimoto. Any other WRs or noes? WR for Representative Holt. Any other WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1348, relating to the labeling of macadamia nuts. Let me preface my recommendation by saying that in the macadamia nut industry, you need producers and processors. You need them both, and we got to figure out a way to work together. I know the mac nut industry. I know the macadamia nut industry well. I have growers in my district. I have processors that I'm familiar with as well, and I've seen how clashing like this it can be really harmful for the whole industry. So I'm trying to find a path forward that would address the concerns of both parties. So with that in mind, I would like to make recommendations for some amendments to this to address the concerns that I have heard that are certainly within the Judiciary Committee's kuleana. I did get permission from the Agriculture Committee Chair to make these recommended amendments. And let me go through them. On page 1, I want to add on line 4 so that it read, I want to add the words branding or otherwise represents so that it would read, if a label on a consumer package contains language, comma, branding, or otherwise represents that all of the raw or processed macadamia nuts contained in the package were grown in Hawaii. So it would continue reading that same. And I'd make the same additional words on page 1, line 11, so that the principal display panel of the package contains language, branding, or otherwise represents. Okay, then on the next amendment, I would like to remove, delete the lines on page 1, line 14, the page 2, line 2. I agree it's vague, and I think it's going to cause problems for the bill going forward. So I'd like to take that out. On page 2, line 14, I want to replace the word label with the words principal display panel so that it's consistent. On page 2, line 14, so after principal display panel, I want to add the words pursuant to Section 304 Tariff Act of 1930 as amended, 19 U.S.C. 1304, marking of imported articles and containers, and adopted in Title 19 of the Code of Federal Regulations, Section 134.11, country of origin marking required. What this does is it's going to actually put into state law the federal law that is requiring provides that every article of foreign origin imported into the U.S. shall be marked in a conspicuous place as legibly, indelibly, and permanently as the nature of the article will permit, in such a manner as to indicate to an ultimate purchaser in the U.S. the English name of the country of origin of the article. So it's already a federal law, we're just going to put it into the state law here. And then the final change on page 4, line 1, excuse me, it's on page 4, line 3, after the word misrepresents, I want to add the words, and creates a reasonable expectation that. So that it will read, to use a label as provided for under subsection B containing the words Hawaii-grown macadamia nuts that misrepresents and creates a reasonable expectation that the origin of the macadamia nuts in the package is being grown in the state. And then I would like to delete the lines 15 to 16 on page 4, which is the private right of action. I think that is onerous, and I think it would endanger the future of this bill. And I want to note that there are other methods of recourse for the industry if it comes to that. But I'd like to take the offer from the processors and producers to work together so it doesn't come to lawsuits. Those are my recommendations for amendments. As I say, I did get the approval of the chair of the Agriculture Committee and the introducer to make those changes. Questions or concerns, members? Wait. No. My attorney is saying, didn't you want to delete this? I said, no, I didn't get permission, so I can't do that. That's my recommendation. Questions or concerns? Yes, Representative Hashimoto.
Thank you, Chair, for your amendments. I appreciate your work on this, but I think there is so much more that needs to go into this to really figure this out. I think number one, if I felt this would help the mac nut industry, I would totally support it 100%. But I don't know if, number one, the Department of Agriculture can really figure this out in terms of enforcing the labeling. I think we need to make sure that DOA has the staffing that they need, and they're not at that place where they can add more things onto their plate. And so I'm very, very hesitant to make this happen. I think, my family is a farming family, and I think we know what it takes to compete with outside products. And so I think you get more out of being, positive versus the regulation. And so I think there needs to be some working group, there needs to be something figured out, but I don't think this is a solution because I just think DOA is not going to be able to do the whole array of enforcements that's necessary. So I'm a no vote for now. Thank you.
Understood. Yeah, I would urge you to talk to the introducer and see if she'll introduce a resolution to create that working group. Other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1348 HD1 with further amendments, noting the excused absence of Representative Ichiyama and the no vote of Representative Hashimoto. Any other WRs or noes?
Reservations.
Reservations for Representative Holt. Chair, your recommendations adopted.
Thank you. Final bill on the agenda, House Bill 201, relating to historic preservation. Members that I've spoken to and the chair of the previous committee would like to move this forward as is with some technical amendments. So that's what we're going to do. House Draft 2 is just with technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 201 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Any WRs or noes? Seeing none, your recommendations adopted.
Thank you. There being no further business before this committee, this meeting is adjourned.